is something that is not any way justified except for the fact that the money is there.
Mr. President, how much time is remaining?
1 minute and 40 seconds
I
remaining.
yield the remaining time to the junior senator from Arizona.
Well, I thank the gentleman. This has been interesting in the area of money being used where it shouldn't be. I gave the example last week on the floor, and I'm making a habit of coming down every week and speaking for at least 5 minutes on waste and duplication in government. But I talked a couple of weeks ago about the Department of Agriculture. Department of Agriculture, this is the Department of Agriculture, but you wouldn't know it when you look at some of the programs run by the Department of Agriculture. One, they have a single-family housing direct and guaranteed loan program in the Department of Agriculture. It provides zero down payment mortgage loans. It's cost the taxpayer about $10 billion since 2006. That's the Department of Agriculture running a housing program. We see this all over government, and it's wrong. Just the duplication, as Senator Coburn, the senator from Oklahoma, has spoken of many, many times, could save our government and the taxpayer billions and billions of dollars a year. So I appreciate my colleagues' this colloquy that we've had, and look forward to more of it. Thank the gentleman.
Mr. President, we yield back the remainder of our time.
Mr. President.
The senator from Maine.
Mr. President, I rise to address one of the most difficult issues that we faced in this bill, an issue that the Armed Services Committee spent a great deal of time, and in fact more time on than any other issue this year, and it's the issue of sexual assault in the military. At our very first hearing, where we were discussing this with a group of people in our hearing, I made the observation that the only sure, long-term way to confront and defeat this tragic problem is through a change in the culture. It has to become unacceptable in the culture of our armed services that sexual assault is in any way tolerated or ignored. We've got to solve this. It's a problem that's been festering for years, and I understand the impatience of those who say we've been waiting too long. We have to take strong steps. And I think it's very important to realize that in the bill that's already before us are strong steps. The most comprehensive package of sexual assault provisions that have ever been in any defense bill, to my knowledge, in the history of this institution. It has been taken seriously. It's been dealt with in a comprehensive way. Some of the strongest changes ever. I think one of the most important that I want to highlight is the criminalization of retaliation. A great deal of the discussion has been about reporting and the reluctance of victims to report, in part because of retaliation. One of the things this bill does is make it a crime to retaliate against a victim for reporting one of these horrendous crimes. So the debate today is really about one particular provision dealing with sexual assault that's not in the bill. And the question really boils down to who makes the decision to refer a sexual assault case to prosecution. And I've heard the debate, and I should have said at the outset, I so admire Senator Gillibrand for her intellect, for her passion, for her dedication, for her perseverance to this issue. Everybody involved in this debate has exactly the same goals, which are to get rid of this problem, to diminish it, to reduce it to zero, to not tolerate it. That's the goal of everyone involved. The question is whether removing the decision to refer to court-martial from the commander will further that goal or, in fact, will undermine it. After listening to the arguments, discussing it at length with Senator Gillibrand and others, I've concluded that to take this decision out of the chain of command would, in fact, do harm to the cause of victims' rights. The reason is simple. I want the commander to be fully responsible for this problem. I don't want a commander saying, it's not my problem anymore. The Congress of the United States has said, I don't have to worry about this. I'll check that box. I believe, going back to my original point, that the way you change the culture is in a multifaceted approach, but certainly one of the ways you do it is through the decisions that come from the commander. That's what sets the tone in the unit. Leadership always infects an entire unit in good or bad ways. And I believe it would be a mistake on the side of the victims if we changed the system and allowed the commanders to say, this isn't my problem, this isn't my responsibility. As Senator Reid mentioned on the floor earlier today, the senator from Rhode Island, one of the most important changes is a change that the Pentagon has itself made, which is to hold commanders responsible for the sexual assault record in their unit as part of their evaluation for promotion. That's part of the way that you change the culture. This is a very difficult decision, but I think it is important to realize that the decision on this amendment is not, are you in favor of victims' rights, are you in favor of the brass? I reject that dichotomy because already within the bill are these very strong provisions which are directed at this serious problem. What we're really talking about is a fairly narrow discussion of who makes that decision. And as a former practicing attorney who's had experience in criminal cases, prosecutors, I think, may be more conservative and less likely in some cases to bring cases to trial than the commanding officer who wants to ensure that justice is done for that victim. What we really want, Mr. President, is no victims. We want this problem to end. We want this problem to change because the culture changes within the military. And that which was acceptable at one time is no longer acceptable. The best example I can cite for that in my life is drunken driving, OUI. When I was a young man, there was an epidemic of drunken driving in this country. And it was considered kind of a joke. It was considered, oh yeah, it was sort of a rite of passage. Subtly and through law changes and societal changes over a generation, it's no longer acceptable. It's no longer funny. It's no longer something that's tolerated, and we've seen a decline because the culture has changed. And that's what has to happen in the military, and I think it begins with the commanding officer. To take this responsibility away from the commanding officer is not siding with the brass, in my opinion. It's siding with the victims. Because I want those commanding officers fully engaged in this decision. I want them fully responsible for this decision. I want them to be what, in fact, they are. Leaders. Leaders who can make change. And leaders who can make change in this critical area. If it doesn't work, Mr. President, as my father used to say, Congress is always in session. We can come back and correct it. I believe that we're at a moment where the military is being given a last chance to deal with this within the chain of command. I think we've given them the tools to do so in this bill, and I urge my colleagues to support Senator McCaskill's amendment and to move forward with this bill, which we can be very proud of in terms of its recognition of this horrendous issue, but also in terms of the solutions and the tools that it provides to our military to solve this problem once and for all. Thank you, Mr. President.
Mr. President.
Senator from Arizona.
Mr. President, I would like to thank my friend and colleague from Maine for his very thoughtful statement, and from having conversations with him, I know he didn't come to this decision easily, but I certainly think he made a very strong argument for the decision he arrived at. He and I and all of us share a deep and abiding concern about the issue that's before the Senate in the form of the amendment to the National Defense Authorization Act on the floor. It's a very difficult situation we are facing. It is an unacceptable situation where men and women in the military may be exposed to sexual assault, but more importantly than that, that individuals who are responsible for those assaults be held accountable. So really what we're talking about here today is, are we going to hold the people who are in charge accountable for bringing to justice those who are offenders, or are we going to farm that responsibility out to some other entity or some other individual or some other part of the bureaucracy? That's the question here before us. I trust these commanders, Mr. President. I've known thousands of them. I trust them and I believe in them. Has there been not sufficient effort devoted to preventing these horrible crimes from taking place? Yes. But do I trust these commanders and these men and women in command to take the proper action necessary? Because it is their responsibility. And I believe with the changes that is already in this legislation, including removing the ability of commanders to overturn jury convictions, to requiring review of decisions not to refer charges, criminalizing retaliation against victims, provide special victims counsel to victims of sexual assault to support and assist them through all proceedings. That's why I supported Senator Boxer's amendment, which reforms Article 32 of the Uniform Code of Military Justice to help to prevent the abuse of victims of military sexual assault in pretrial setting. So we are taking action in this legislation, and maybe we can be found guilty of not acting soon enough. But to somehow say, and basically this is a fundamental question, do we not trust the commanders whose responsibility sometimes is the very lives of the men and women under their command? Do we trust them to do the right thing or not? So that's really the difference between the Gillibrand Amendment and what has already been done in this legislation, which after extensive hearings, debate, and discussion. Do we trust the commanders to do the right thing with the proper parameters, like removing the ability of commanders to overturn jury convictions, to require review of decisions not to refer charges, criminalizing retaliation against victims? We have taken, as far as I can tell, a significant and important steps that will protect men and women not only from the assault but the abuses that may take place and recriminations that may be visited upon them in case of the fact that they are victims. I'm not saying that this legislation that we have before us will eliminate sexual attacks, but I am saying sexual assaults, but I am saying that what we are doing is exactly what we did at other times when there were crises in our armed forces, and I refer back to the post-Vietnam War era. I can tell you, Mr. President, that I was a commanding officer in 1975, 6, and 7, and we had racial problems, we had drug problems, we had discipline problems, we had the post-Vietnam War syndrome where our military was in total disarray. Drugs, racial discriminations. There had been race riots on aircraft carriers. And what did we do? We placed responsibility direct on commanding officers, and if they didn't take action and if they failed, they were relieved. That's the way the military should function, and that's the way the military has functioned successfully. And we had programs, and we had advisors, and we had indoctrination, and we had punishment. Punishment for those who refuse to adhere to the standards of conduct that we expect every man and woman in the military to adhere to. So what does the Gillibrand Amendment do? It removes the commander. It removes the person, the man or woman in command, who has got the ultimate responsibility, unfortunately, from time to time, of taking these young people into battle and risking their very lives. That's what makes them different from any other part of America and any other part of our society. So the Gillibrand Amendment, of course, is, well, we don't trust these commanders. Well, we trust these young people with their lives. We ask them to have the ultimate responsibility, which is that of defending this nation, but we don't trust them to prosecute, to do their job, to do their duties. Well, Mr. President, that flies in the face of every encounter I've had with the men and women who are in command and the senior petty officers, the Master Chief Petty Officers and the Master Sergeants that are responsible for the good order and discipline of our men and women in our armed forces. So I won't go into the fact that this Gillibrand Amendment includes things like burglary and housebreaking and perjury and robbery and forgery. It's been expanded beyond belief in its areas that have to be referred out of the chain of command. I won't even bother with that. But what I am saying, and I say it as passionately as I can to my colleagues, that if we do not trust the commanding officers who take our young men and women into battle, our most precious asset, if we don't trust them, then we obviously had better reevaluate our entire structure of the military. But I do trust them, Mr. President. I do trust them. The finest people I've ever known in my life are those we have given who have worked their way up to positions of authority and command through a very severe screening process. Have they made mistakes? Can we find an example or a case where a right thing was not done? Of course we can. There's nowhere in our society that we can't find examples of people having not done the right thing. Today I'm embarrassed that it seems that naval officers were involved in some kind of bribery scheme about overseas ships. And from time to time we are embarrassed by leaders of our military. But they are the exception and not the rule. And so, if you pass the Gillibrand Amendment, my friends, you are sending a message to the men and women in command in the military: we don't trust you. We don't believe in you. That's what this is all about. But if we do, with these significant changes, 26 changes in the Defense Authorization Bill, to ensure that if there is a wrong decision made, that decision has to be reviewed, in some cases, all the way up to the Service Secretary. That anything that is done regarding this terrific problem, and it is a terrific and horrific problem in our armed forces today, but we have done what we believe and what the military believes and what our military leaders believe is the right thing by leaving the commanding officer in the decision-making process concerning the lives and welfare of the men and women under whom they command. So, Mr. President, I hope that we will realize that if we pass this amendment, the Gillibrand Amendment, our signal to the men and women in leadership, whether they be our senior enlisted personnel or our officers: we don't have any confidence in you. We don't trust you. That's the message that will be sent if we pass this amendment today. And are they perfect? No. Have they made mistakes? No. That's why we put provisions in this bill which would circumscribe much of the decision-making process, but still leaves final decisions in the chain of command. I urge my colleagues to reject the Gillibrand Amendment. I yield.
Mr. President.
Senator from Nebraska.
Thank you, Mr. President. I rise today to speak on the series of historic reforms adopted by the Armed Services Committee to combat sexual assault in the military. Though women have taken the lead on this matter, sexual assault is not a gender issue. It is a violence issue. I rise to voice support for a bipartisan amendment that I've offered with Senator McCaskill and Senator Ayotte to directly confront this violence. And I rise to urge my colleagues to oppose any radical changes that would undermine justice for the victims and take away responsibility from commanders. I'm proud to have supported several measures to strengthen the rights of victims, hold perpetrators accountable, and strengthen oversight of military commanders to ensure that justice is delivered. As a result of a truly bipartisan effort, the committee has put forth a bill that takes an unprecedented step of providing victims with a special victims counsel to make certain they are receiving unbiased, independent legal advice. It strips commanders of the ability to overturn jury convictions, makes retaliation against victims a crime, requires dishonorable discharge or dismissal for those convicted of sexual assault, and provides critical civilian oversight. Despite achieving these unprecedented reforms in committee, my colleagues and I continued to explore ways to enhance the current bill after the committee's work had concluded. Senators McCaskill, Ayotte, and I introduced an amendment last week to expand upon the committee's progress. Our proposal extends current protections to service academies, boosts evaluation standards for commanders, and allows victims increased input. It also eliminates the good soldier defense in most cases. These changes, both in our amendment and in the whole NDAA, are significant. But importantly, they are also serious and they are thoughtful. They are based on sound policy, not on political sound bites. Rather than radically remaking the entire military justice system, which would carry significant risk, our proposals improve and update the current system. To do so, we applied lessons from history. In 2006, Congress hastily changed portions of the Uniform Code of Military Justice to address instances of rape. These changes disrupted victims' paths to justice, and Congress was forced to rewrite its own changes a few years later. Congress can't afford to get something this important wrong. We cannot let our deep desire to solve this problem lead to imprecise solutions, because victims suffer when we do. Any changes to the UCMJ should come after a deliberate and transparent process with feedback from all sides. The McCaskill, Ayotte, Fisher Amendment is the result of such a process, and I encourage my colleagues to support it. Finally, I urge my colleagues to oppose any amendment that undermines a commander's responsibility for his or her troops. Senator McCaskill put it so well when she spoke on the floor earlier today. The amendment offered by my friend and colleague, the junior senator from New York, offers a solution that is, quote, seductively simple, but its simplicity cloaks a host of complex policy problems. In addition to technical concerns, I do not agree with the underlying goal of removing commanders from the military justice system. As Senator McCaskill noted, we know that commanders pursue courts-martials when their legal advisors recommend doing so, against doing so. We know, based on the experiences of our allies, that removing commanders from that judicial process does not achieve the desired results. And we know that commanders have risen to the challenge in the past to confront contentious issues within their units, including integration. These facts lead me to conclude that the changes in this bill combined with the reforms included within our amendment, will best serve the interests of victims and punish those responsible. Mr. President, I commend the senator from Missouri for her leadership on this issue, and I am grateful for the opportunity to work closely with her, Senator Ayotte, and many other colleagues to help our men and women in uniform. I yield the floor.
Mr. President,
Senator from Oklahoma.
first of all, I agree with the comments of the senator from Nebraska, and I have to say that I was a little disturbed. I've heard a couple of reports. One was in a news conference on November 6th, and one on the 19th, only that's yesterday, I guess, that Senator Gillibrand was saying that I was objecting to her amendment. Yes, I oppose her amendment, but not to the extent that I would hold back the bill. My gosh, there's no one on the floor of this United States Senate who's been working harder to get this bill in, no two people more than the chairman and me. And so I want to make sure that people understand that. Now, in terms of the alternative, I've been watching it very closely, and my strongest possible support is for that amendment 2170 by Ayotte and McCaskill, that provides additional enhancements to the historic enhancements of the sexual assault prevention and response activities in our military. I commend my two colleagues of the Armed Services Committee, both of them are on the Armed Services, for their tireless efforts in their leadership, and urge all senators to join me in supporting this amendment. Now, it doesn't mean that if you're opposed to the Gillibrand amendment that you're not wanting change. Well, yes, we do. This is major change. It adds the senior trial counsel to the officers who make recommendations on whether to proceed to trial, and if the convening authority decides not to proceed, results in the case being referred to the service secretary. It adds duties for the Special Victims Counsel to inform victims of options for military and civilian prosecution of sexual offenses. It gives them a voice. They can express a preference. It requires commanders to give weight to that preference and to notify the victim if the civilians decline prosecution. These are changes. These are changes in the current system that are coming with the amendment by Ayotte and McCaskill. Amendment number 2170. It requires including a written performance appraisals for every member of the armed forces, officers, and enlisted people, an assessment of that member's support for sexual assault prevention and response programs. It requires every commander to be evaluated in their performance appraisals on whether they have or have not established a command climate where allegations of sexual assault are properly managed and fairly evaluated, and ensure a victim can report sexual assaults without fear of retaliation, ostracism, or any kind of group pressure from members of the command. It also requires command climate assessments to be performed after a sexual assault incident, with copies of that assessment to be provided to superiors in the chain of command and the Military Criminal Investigation Organization. And it creates, finally, a process through the boards for correction of military records, for confidential review, for discharges, for individuals who were victims of sexual offenses, to require consideration of psychological and physical aspects of the victim's experience that may have had a bearing on the separation. So I just want to say this is a major change. It's one that I strongly support. And I just would give the senator from New York the benefit of the doubt that she did not mean what some people interpreted as to I would hold up a bill in opposing her amendment. I certainly would not do that, but I am for reforms that we have a great opportunity that is bipartisan to do that and accomplish that very thing that we should have accomplished many years ago. Is there any more? Oh, didn't know you were here. I thought there's others waiting here, but let me just make one comment. Put that chart up, would you? I agree with my colleague, the junior senator from Oklahoma. I know that he has worked tirelessly in trying to do something to stop waste in the Pentagon, and quite frankly, I think it's there's some there. But I just want to show this chart. This chart shows the devastation of sequestration. And what it shows is the bottom line these are the efficiencies. This is what he's talking about. Now, I want you to see this because this goes from fiscal year 14 all the way to 23. And if you take the sequestration as it is right now, without any adjustments. Now, Senator Sessions, Senator McCain, and I have tried to make adjustments in there so that there are greater cuts back here and not so many in the first 2 years. The orange, and that's where almost everything comes out from, that's readiness. That's readiness. That's what we need to support our fighters in the field to save lives. Now, the green is modernization. That's not affected by these inefficiencies that we're talking about. The force structure, that's a major cost item. That's the yellow in there. So what I'm saying is, yeah, I know there's room for improvements, and I want Senator Coburn and others to work on areas within the Pentagon where money can be saved. But if that happens, it's still going to be all found down here. I mean, everything, TRICARE and all of it's down in this blue line, so you can see that the devastation that comes with sequestration to our military is still going to take place. I think if you look at the level there of the sequestration cuts that takes place, it's almost entirely in the readiness. Readiness is a term that we've used for a long time, and that's our ability to save lives. That's our ability to train and equip our men and women in harm's way. And we have testimonial right now I want to share with my good friend in the chair who was there and heard it from all 4 services talking about how much more risk is involved if we have to go through sequestration. And risk equals lives. And so I just think that I agree with those who want to do all they can through efficiencies. I'm for them. I would do all I can to help them. But that doesn't solve the problem. The problem is immediate. It's today. And I still believe that should be something we could do to stop draconian cuts in our readiness and our force structure accounts that would come with sequestration. It wouldn't do me any good to read all the quotes that we have from the various individuals, but I can assure you the chair and anyone who's sat through any of our armed services hearings have heard all 4 of the chiefs talk about how devastating this will be if we're not able to correct it to some level. With that, I yield the floor.
Clerk will call the roll.
Mr. Alexander.
Mr. President.
The Senator from Hawaii.
Mr. President, I ask unanimous consent that the quorum call be vitiated.
Without objection.
Mr. President, there is not a single senator here who does not acknowledge the seriousness of sexual assaults in the military and that we must do something to prevent and prosecute these crimes. And yes, there are differences of opinion as to what we need to do, but make no mistake, we share the common goal of preventing and prosecuting these crimes. I want to thank the leadership of 2 strong women on the Armed Services Committee, Senators McCaskill and Senator Gillibrand, for their leadership in pushing for solutions that will make a difference. I also want to thank Chairman Levin for his commitment and leadership in bringing forth a bill that includes a number of important improvements to the current system. We all support these changes. However, I believe there is a fundamental structural problem with how sexual assault cases are prosecuted in the military. We need to make the changes proposed by the Gillibrand Amendment. I am a co-sponsor of Senator Gillibrand's amendment. I spoke on the floor last week and explained why I think we need to remove disposition authority from the chain of command. I don't want to repeat everything I said last week, so let me make just a few points. First, for 2 decades or longer, the Department of Defense has had a zero-tolerance policy for sexual assault and sexual harassment. Yet the problem persists. Service members continue to be assaulted and raped, and in too many cases, the perpetrators continue to go unpunished. Year after year, secretary after secretary and commander after commander have told us about all the efforts to correct this problem. But those efforts have not worked. There are probably many reasons why these incremental changes have not worked. But every year that these changes do not work, many more of our brave men and women in the military endure the trauma of sexual assault. It's time to make a major change to the military justice system. Second, too often, these attacks are not reported, which allows the attacker to prey on more victims. The survivors tell us the biggest reason they do not report these crimes is because they do not believe their chain of command will ensure that justice is done. Even the Commandant of the Marine Corps, General Amos, has acknowledged that many victims do not come forward because, quote, they do not trust the command, end quote. The concerns of survivors in coming forward make sense because there are inherent biases and conflicts of interest in the chain of command. These concerns are echoed in a letter from General Claudia Kennedy that was signed by more than 24 former officers from all branches of the military. The letter states, quote, we know that in too many cases, service members have not reported incidents of sexual assault because they lack confidence in the current system. The inherent conflicts that exist in the military justice system have led service members to believe that their allegations of sexual assault will not receive a fair and impartial hearing and that perpetrators will not be held accountable, end quote. We should give weight to these concerns and act today to remove the chain of command from prosecutorial decisions in sexual assault cases, and instead put these decisions in the hands of an impartial, experienced military lawyer. Third, removing prosecutorial decisions from the chain of command will not harm good order and discipline. I've heard this concern from many military leaders as well as from others who oppose this amendment. They say eliminating a commander's ability to decide whether a case should go to trial would undermine the commander's ability to maintain good order and discipline within the unit. And yet, we have heard from many others who have command experience who support the Gillibrand Amendment. Good order and discipline should not depend upon a commander's ability to decide whether or not to prosecute a sexual crime. A commander's authority and leadership must certainly be based on more than that. Furthermore, the Gillibrand Amendment preserves the commander's disposition authority over crimes that are uniquely military, crimes such as desertion, AWOL, contempt, and noncompliance with procedural rules. This ensures that commanders will have the authority they need to maintain good order. In closing, it is undeniable that the current system does not work. We know it doesn't work because according to the Department of Defense, in 2012, there were an estimated 26,000 cases of unwanted sexual contact. We know that not all survivors report these crimes because, in the words of General Amos, quote, they do not trust the command, end quote. We know that we can eliminate bias and conflicts of interest by entrusting prosecutorial decisions to an impartial, experienced military lawyer. And we know that removing disposition authority from the chain of command will not undermine good order and discipline. We know what needs to be done. We ought to do it, and do it today. We owe it to the men and women who serve our country in uniform. We owe it to the families and loved ones of those who serve, because the trauma of sexual assault often extends beyond the trauma experienced by the survivor. I urge my colleagues to support the Gillibrand Amendment. I yield the floor and notice the absence of a quorum.
Will the senator withhold the request?
Mr. President,
Mr. President, I withhold my request.
The senator from Michigan.
Mr. President, the bill that was reported by I yield myself 6 of my 10 minutes. The bill that's reported by the committee includes groundbreaking new measures to reduce sexual assault and misconduct. On a bipartisan basis, members debated and approved more than 24 measures related to preventing sexual assault and to delivering justice for the victims of these crimes. The bill that we approved and which is now before us would provide sexual assault victims a counsel, a lawyer who works not for commanders, prosecutors, defense attorneys, or a court, but for the victim. It includes strong new protections for victims that are designed to combat the #1 problem we have in preventing assaults and dealing with perpetrators, the fact that many assaults remain unreported to authorities. And of great importance, the committee-reported bill, for the first time, makes it a crime under the Uniform Code of Military Justice to retaliate against a service member who reports a sexual assault. It also requires that the Department of Defense Inspector General review and investigate any allegation of retaliation against those who make communications regarding sexual assault or sexual misconduct. Our bill includes important criminal justice system reforms, including reforms on how commanders respond to sexual assaults. Our bill includes a requirement that commanders who become aware of a reported sexual assault immediately forward that information to criminal investigators. It eliminates the consideration of the accused's character from the factors that a commander should weigh in deciding whether to prosecute a sexual assault allegation. It restricts the authority of commanders under Article 60 of the UCMJ to set aside court-martial verdicts in cases involving sexual assault and other crimes. It requires a decision by a commander that he will not prosecute a sexual assault complaint to undergo an automatic review by a higher command authority in nearly all cases of a general or flag officer, and in the case where a commander's decision not to prosecute contradicts the recommendation of his or her legal advisor, that automatic review is conducted by the service secretary. And the committee-reported bill also makes clear that we expect and demand that commanders will use their authority to rein in this problem by fostering a climate of zero tolerance towards sexual misconduct, and one in which service members believe they can come forward to report cases of sexual assault. These important reforms were the work of almost every member of the Armed Services Committee. The desire to remove this stain from our military is bipartisan, and it is strong. Now, Mr. President, perhaps the most basic reason to oppose an amendment of the senator from New York is this. It removes a powerful tool from those who are indispensable to turning the problem that we have around. Our military commanders are the indispensable tool to turn this problem around. I have met at length with several groups of retired military women. I specifically chose to meet with retired military personnel to ensure that they would be free to speak their minds. These women, all of whom have seen cases of sexual assault and sexual harassment in the course of their military careers, told me the problem is not commanders. The problem is a military culture, they told us, that tolerates excessive drinking and barracks banter that borders on sexual harassment or crosses that line. The problem is that there's a failure to recognize the existence of service members who appear to be good soldiers, but in fact they're sexual predators. A culture that values unit cohesion to such an extent that those who report misconduct are more likely to be ostracized than respected. None of these problems is unique to the military, but they are exacerbated in the military by the frequent rotation of military assignments, which can make it easier for predators to hide. Now, the military has a unique tool for addressing this problem: commanders, who can bring about changes in command climate through mandatory training by issuing and enforcing orders that are not possible in a civilian environment. And that is what they did in addressing racial discrimination and in ending Don't Ask, Don't Tell. That is what they can and should do here. Weeding out sexual predators in the climate that makes it possible for them to hide is an essential ingredient in any solution to the sexual assault problem. And the military women that I met with over the summer told me that our commanders are in the best position to make that change. Weakening the authority of commanders will do serious damage to their ability to accomplish this change. All of us seek the strongest, most effective response to the plague of military sexual assault. The amendment that Senator Gillibrand proposes will not strengthen our response. The evidence before us shows it will, in fact, weaken our response by removing the decision from the hands of commanders. We have 24 historic reforms in our bill, but a number of senators, led by Senator McCaskill and Ayotte and Fisher, have continued to work on policies to strengthen our response to the military assault problem. And this has resulted in the amendment that they have proposing. And, Mr. President, I will conclude by saying this. These additional reforms of the McCaskill-Ayotte-Fisher amendment are significant additions to what is in the committee bill, and I support them. What I cannot support, and what I hope the Senate will not support, is legislation that will remove from our commanders the authority to combat this problem. The real, strongest tool to combat this problem is the ability to send a matter to a court-martial. We cannot strengthen our efforts to prevent sexual assaults by reducing the likelihood of prosecutions. And we know from history and from the facts that that is the result of taking this decision away from the hands of commanders. We know of the 100 cases where other authorities, civilian authorities, have decided not to prosecute, but where the commanders then decided to pursue it anyway. That's just in the last 2 years. And we don't know of any cases that go in the other direction. We cannot strengthen our efforts to prevent sexual assaults by reducing the likelihood of prosecutions. We cannot strengthen our efforts by weakening the authority of our commanders to act against sexual assault. Commanders were tasked again with making those monumental changes in military culture, from combating racial discrimination in the 50s to ending Don't Ask, Don't Tell in 2011. If we're to accomplish the change in military culture that we all agree is central to combating sexual misconduct and sexual assault, commanders are essential. We can't fight sexual predators if we make it more difficult to try and convict them, and we cannot hold our commanders accountable for accomplishing the needed change in culture if we remove their most powerful weapon in the fight. I would ask, Mr. President, unanimous consent that the balance of my statement be inserted in the record, and I yield the floor.
Without objection.
Mr. President,
The senator from New York.
I want to thank Chairman Levin for his extraordinary leadership on combating sexual assault in the military. He has led a process over the last year to ensure that our base bill has a set of historic reforms that make a huge difference in how cases that are actually reported are handled. And in fact, the reforms that Chairman Levin has put forward and that our colleagues are continuing to perfect do make the handling of the cases that are reported better. They make sure that every victim that reports has a victim's advocate to help him or her steer through the process. They also make sure that if that victim is so lucky enough to get that conviction, that it can't be overturned by a commander on a second-level review. They also make sure that we have better record keeping. They make sure that the rules of evidence are better. They make sure that victims are protected throughout the process. And most importantly, we as a committee have put forward in the bill a law that makes sure retaliation is now a crime. Those reforms help the victims who are strong enough and able enough and have a command climate that is strong enough to report their cases. But one thing the chairman said that is not true. Commanders do not need this legal right to be able to set the command climate. In fact, most commanders will never have this legal right. Just looking at the Army rankings, second lieutenant, they will command 16 to 44 soldiers. They do not have convening authority. First lieutenant commands 110 to 140 personnel, do not have this authority. Captains, 62 to 190 soldiers, do not have this authority. Majors, lieutenant colonels who typically command battalion-sized units, 300 to 1,000 soldiers, do not have this legal right. Most commanders will never get to look at a case file and say, are we going to trial? So I disagree that the ability to decide if something goes to court-martial is necessary to set good order and discipline, because almost every commander, all of them here, these commanders, they all have to set good order and discipline as part of their job. They have to set a command climate where the rape doesn't happen. They have to set a command climate where that victim feels comfortable enough to come forward, and they must, by law, now ensure that victim is not retaliated against. It's their job, whether they ever have this right. Commanders can do this and must do this without this legal right. It does not weaken their ability to have one guy way up here in the Army who wears the bird, the man who is the colonel, 06 level and above. He will make a legal decision, and he is not a lawyer. He is not trained. He does not know the ins and outs of prosecutorial discretion. He may be biased. He may value the perpetrator more than the victim. He does not need to make this legal decision, and he shouldn't be judged on how tough he is on crime. He shouldn't even be judged after he weighs the evidence if he does his job properly. He should weigh the evidence fairly. And you can only do that if you are objective, and that's why we wanted to go to trained military prosecutors outside the chain of command. Those commanders, every single one of them should be judged on what the command climate is. And most of them will never get to weigh legal evidence as part of that. Chairman Levin, my colleague, has said they've never heard of examples where commanders didn't go forward, but a lawyer did. I talked about one this morning. We heard from many victims. In fact, one victim said she was on her way to trial, and the commander was changed, and the new commander had been in command for 4 days, and he decides that the trial's not going forward. He actually discontinued the trial. And you know what he said to her? Your rapist wasn't a crime. He may not have been a gentleman. So, Mr. President, I do not believe this legal right undermines our military system. I believe it strengthens our military system. I believe it gives commanders the chance to do their job, fighting and winning wars, training men and women. Commanders are entirely on the hook by our base legislation. They will be judged on the command climate. They will be judged on whether there's retaliation. They will be able to prosecute retaliations as crimes. I believe that if you create transparency and accountability in the system, we will be able to have many more cases be reported, first of all. More of those 23,000 cases will be reported.
When you have more of 23,000 cases be reported, you will have more investigations. You will therefore have more trials. You will therefore have more convictions. If you are ever going to change the culture, you need to do it by showing there's accountability. You need to show it by showing there's justice. You need to show it by showing justice can be done. We need the active involvement of commanders. This is never going to happen if we don't. So they need to start focusing on retaliation. They need to start focusing on command climate. They need to make sure these rapes aren't happening. And they will do that whether or not they ever have this legal right. When our allies changed their laws to elevate all serious crimes out of the chain of command, they didn't see a falling apart of their military. They didn't see good order and discipline going out the window. They didn't see any change at all, in fact. So I know our military can do the same. I know our military can build a transparent, accountable system that responds to what victims have asked. They want to be able to have the decision maker be outside their chain of command. If we do that, we have a chance of building a criminal justice system within our military that is good and is just as our men and women deserve. I yield the floor. Mr. President, I suggest the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
We just heard from Senator Gillibrand, whose amendment dealing with sexual assaults on the military has been getting much debate throughout the day today. Debate on sexual assaults started at about 10:40 Eastern this morning. And CQ Roll Call writes that as the debate got underway, Senator Gillibrand acknowledged that she's still a few votes shy of the 60 that she'll need to attach her amendment to the annual Pentagon Programs bill. Senator Gillibrand's amendment would take the decision for prosecuting major crimes out of the hands of military commanders. Instead, trained military lawyers would decide whether to move forward with cases. Senator Gillibrand has the support of more than half the Senate, but her proposal has been strongly opposed by military brass and key lawmakers, including Senator McCaskill. The story in CQ Roll Call goes on to say that Senator McCaskill's amendment would, among other things, require new special victims counselors trained to handle sexual assault cases to advise victims on the advantages and disadvantages of their cases being prosecuted in the civilian or military justice systems.
Request that Major Aaron Jelinek of the Air Force, currently serving as a defense fellow to Senator Begich's office, be granted privileges of the floor during consideration of S-1197, the National Defense Authorization Act of fiscal year 2014.
Without objection, so ordered.
I also have a statement for the record that I'd like to enter, which responds to some of the technical concerns that our colleagues had about the filed amendment. We actually made significant changes to address those technical concerns, and I have a full analysis and description of them that I'd like to appear in the record.
Is there objection? So ordered.
Thank you. I suggest an absence of the quorum.
Clerk will call the roll.
Mr. Alexander.
Work on the Defense Programs bill is expected to continue here in the Senate tomorrow. And coming up here on C-SPAN 2 this evening, we'll be live from the 2013 National Book Awards being held in New York. Maya Angelou will receive an award for outstanding service to the American literary community. And you'll also have a chance to see the presentations of the awards for nonfiction, fiction, poetry, and young people's literature. Also, the red carpet arrivals of the event will also happen. That's at booktv.org starting at 6 Eastern. And then our live coverage here on C-SPAN 2 gets underway at 7:40 Eastern and again at 9 tonight. And in addition to the House and Senate tomorrow, we'll also have live coverage of the Senate Judiciary Committee holding a hearing on oversight of surveillance agencies. That's live at 10 Eastern on C-SPAN 3. And a little later in the day, in the afternoon, at 2:15 Eastern, the Senate Foreign Relations Subcommittee will meet about the political situation in North Africa. That's also on C-SPAN 3.
Mr. President.
Senator from Delaware is recognized.
Mr. President, I ask unanimous consent that proceedings under the quorum call be vitiated.
Without objection, so ordered.
Mr. President, I come to the floor today to speak